Hello, and welcome to The Law. It's your legal light. It is your help law. I'm Samson Ladi Anyanini, and this afternoon we ask the question, should it be a constitutional review or a completely new one? We'll be right back. Welcome back. President Mahama has set up a Constitution Review Committee to examine gaps in the 2010 Constitution Review Commission's work as well as the 2024 Constitution Review Consultative Committee's work. They are supposed to produce a report in 5 months. The Democracy Hub organized a forum in which they insist we need a new constitution and not review this constitution.
Stagnant thrum of power, a tethered drum beating to the same tired hand. This is not the melody of progress. It is the heavy drone of power gone stale, ago. It clings to the skin of nations like dust after the dry season. Imagine a village where the river no longer flows, where water pools thick, stagnant, breeding diseases while life would have danced there. Ago. Do you see it? This is what happens when power sits for too long. When one man's shadow stretches across generations until it blots out the sun. In a distant field, an elder sharpens his machete under a baobab tree. His hands are calloused. His face is worn with the lines of a story which he cannot tell.
Professor Jima Bwedi of the CDD was chairman of the occasion. He underscores the need for constitution review.
Doing something about the constitution is compelling if you are thinking in terms of taking into account the fact that we have a younger generation. Those of us, people in my generation, who had experienced life under authoritarian military regimes and the like, may have a different attitude to the democratic system we have today. That may not apply necessarily to the younger ones.
But why a completely new constitution? Oliver Barker-Vormawor tells us why.
Surely a new constitution cannot fix a broken people. It is a fair and often overheated argument that people make. How can the constitution fix a broken people? Shouldn't we fix ourselves first? At first glance, this seems to point to a deeper truth about personal and collective responsibility. But let's examine it more closely. Because while it raises valid concerns, it risks oversimplifying a complex issue and undermining the transformative potential of institutional change. People do not exist in a vacuum. We are shaped by the systems we live in, the rules, the institutions, and structures that define how power is distributed, how justice is served, and how opportunities are assessed. When those systems are dysfunctional, they can reinforce and perpetuate the very behaviors and attitudes we often describe as broken. For example, if corruption thrives within a system because there are few consequences for bad behavior, it becomes normalized. If inequality persists because institutions are designed to benefit the few at the expense of the many, it breeds resentment, hopelessness, and disengagement. In such an environment, even the most principled individuals find it difficult to flourish. A new constitution provides an opportunity to redesign these systems so they uplift rather than suppress the best in us. The argument that we must face ourselves first assumes that cultural and moral transformation must precede structural change. But history tells a different story. Transformational moments, whether they involve new constitutions, the civil rights movements, or dismantling of colonial rule as we have seen in our past, often lead to societal attitudes, to shifts in societal attitudes and values. Structure and culture are not sequential. They influence each other in an ongoing cycle. But this is not to suggest that a new constitution will be a magic wand. It will not solve all our problems overnight, but it can create the conditions which allow healing and progress to be possible. It can provide a scaffolding for a society where our best instincts, rather than our worst, are rewarded and reinforced. But surely all of this is prose. Perhaps I'm offering you nothing inspiration without substance. Again, what about the current constitution is so broken that it cannot be accommodated by a review? It is not enough to inspire. It is also important to be clear and precise about what is exactly broken about this current constitution. So allow me to delve into some of the fundamental structural flaws in Ghana's 19th constitution, why we argue a complete overhaul rather than piecemeal amendment are necessary. First of all, our call for a new constitution has come about due to two limitations that we think is present in the current and overwhelming calls for a review of the constitution. First is what we call the process question, and second, the content question. What is the moral compass of the proposed reforms? Let me start with the process question. As many of you recall, the Constitution Review Commission put together over a 1,000-page document which covered 12 thematic areas broadly, dealt with 177 distinct issues, and there were 478 recommendations that were made, categorized under constitutional, legislative, and administrative changes. Now here's the critical point. 264 of those recommendations require direct amendments to the Constitution. Put that in context. The 1992 Constitution has 298 articles. This tells you how extensive even the review was. Nothing was spared, not even the preamble. To the process question. Chapter 25 of the Constitution currently divides the Constitution into two parts: entrenched provisions and non-entrenched provision. The Constitution Review Commission's approach was that it was going to group all the non-entrenched amendments in one bill and all amendments touching the entrenched provisions in another bill. So two bills were proposed. And if you take the report and the back of it, you see two draft amendment instruments included. This is where it begins to get interesting. I saw the statement from the presidency that appoints a new commission. And it refers to the work of the Constitution Review Commission. But one of the things it doesn't refer to, surprisingly, is the white paper that followed that work. The white paper, as the kids called, I remember when the white paper dropped, my former colleagues from the Constitution Review Commission drew lots, and the lot fell on me as the youngest to prepare what we call the variance report, the distinction between the white paper and what the recommendations of the commission were. Out of the 478 recommendations, the white paper accepted 229 recommendations, rejected outright 55 of them, and changed 27 of them. The white paper did not comment on 167 of those recommendations, leaving their legal status in a bit of a limbo. Now, critically, most of the rejected recommendations related to constitutional provisions. I'll try to give you a flavor of some of the rejections, okay? One, the Commission recommends that the Constitution be amended to include the basic principles of children's rights. That is the best interest of the child, non-discrimination, right to life, survival and development, right to life, right to health, participation and sense of responsibility according to evolving capacities. The presidency rejected this. Somehow the 1992 Constitution is incompatible with children's rights. It was recommended that the National Development Plan be binding, which was what Ghanaians were calling overwhelmingly for, and be entrenched. Not accepted. It was said that every citizen would have the right to enforce a national development plan for the country. Not accepted. It was said that the National Development Planning Commission would be independent, professional, multi-partisan. Not accepted. It was said that it should reduce the number of presidential appointees to the Council of State. Not accepted. That the MMDCs in metropolitan areas should be elected by direct suffrage. Not accepted. The Commission also recommended that Article 14.3 of the Constitution be amended to reduce the time beyond which a person may be detained before being brought to trial from 48 hours to 24 hours. Not accepted. After the white paper came in, the Constitution Review Commission, had recommended that we set up a Constitution Review Implementation Committee. We call it CRIC. And their job was to then implement, I guess, in substance, the white paper report. But then the Attorney General took a new position, that it would be unconstitutional to put all the proposed amendments into two separate bills. Instead, all the recommendations would have to be proposed and go through their own individual Chapter 25 process, separate and individual bills. There was also some confusion whether there was the need for one single referendum for all the provisions, amending the entrenched provisions, or for every question deserved its own referendum. Then there was also Parliament. Of course, Parliament. I remember during the Commission's time, when Parliament was consulted about the review, they wanted two things. One, make sure that dual citizens do not contest for MPs. Two, make sure that MPs can get appointed as ministers and don't touch anything else in the Constitution. Parliament, for its part, insisted that for all the entrenched and non-entrenched amendment bills, that they had the constitutional power to make changes to them when they were laid before Parliament. These questions continue to remain unsettled, and I trust that they will continue to haunt the process as we go forward. But I want to put you through a thought process, okay? If we were to accept the view as correct, that is something undemocratic about bundling 50 amendment bills into one single referendum question, and asking people to accept them yes or no, how many referendums can we hold to feel like we have properly reviewed the Constitution? And if we say all we need is one referendum, but separate questions, how many questions can we ask for the people to vote on at the time when they stand beyond the ballot box? Secondly, if we are to accept Parliament's proposition that the amendment bills for non-entrenched provisions must be individually done, are we to push the 100 bills all through at once, or does it propose that we table them and discuss them one after the other? Now, if the regular legislative process would take, let's say, a minimum of 1 year, because you need to gazette the bill for 6 months before you even start, it means that it will take 100 years and roughly 25 presidents to finish the amendments identified 100 years ago, because that's when we would have reached. I'm only asking these questions, and I don't intend to ridicule, of course. So instead of navigating this legislative maze, we propose a simple and more practical approach. Redraft the entire Constitution, whether it be based on the CRC's recommendations and new thinking that has emerged, and present them for national approval in a single referendum. In other words, if we take all the 200 recommendations and redraft a new document, we can present it. We don't have to wait 100 years. Now, the country has had experience with adopting new constitution. We've adopted 5 of them. We do not have a history or any template for how we review the Constitution holistically. So a new Constitution, we believe, is a window into deblocking legislative gridlock and paralysis. Now to the content issue. First of all, it is wrong to presume that a new Constitution necessarily implies that all that is good from the past cannot be preserved. Some have said we're proposing to throw the baby away together with the bathwater. Not at all. We're proposing to throw away the bathwater and rinse the baby. First, we must define what the moral compass of this new project is. The last process told us that they intended to move the document from a political document to a developmental constitution. To do this, their big idea was to reform the National Development Planning Commission and use that commission or development as a window of change. What happened to this? Not accepted. We think our inspiration for reform must align the Constitution with our national creed: freedom and justice. Development is too vague an idea. Freedom and justice do not convey shifting meanings. They must be our moral compass. I'll get down to some of the things that you've been waiting for. Democracy Hub is making 16 proposals for constitution remaking. First, the popular initiative, which is the power of the people. The current constitution proclaims that sovereignty resides with the people, but this is far from reality. It provides no mechanism for the people to directly propose constitutional amendments. When first the country launched the 1 million signatures for a new constitution, people told us that, but there's no way in which you can use 1 million signatures to change or influence the Constitution. And there is the democratic question. If a single president can initiate constitutional reforms, why can't a million Ghanaians? That imbalance must be resolved. And precedent exists and exists in Kenya. 2, we are proposing proportional representation in parliament. The existing parliamentary framework entrenches a dysfunctional two-party system that stifles diversity and innovation in our governance. Smaller groups, such as environmental advocates, climate activists, or ideological movements like the Green Party, are structurally excluded in our governance. The new constitution must mandate proportional representation to allow parliament to reflect the diversity of Ghanaian society. Now, I've been flagged that I have 2 minutes to go, but we have 14 more to go. I'll be briefer than I have been. Decentralization. The current decentralization framework is a facade. While electing district chief executives may seem democratic, fiscal control remains centralized in Accra. Local governments rely on meager and delayed transfer from the common fund, rendering them powerless to effect change. We demand that the Constitution mandates allocation of at least 40% of national revenue to local governments. Democracy cannot function if power and money remains in Accra, while development is expected in Zabzugu or Tatale. 4, eliminating age-based restrictions. Our constitutional age restrictions for political participation are out of sync with the country's youthful population, where our current average age hovers around 17. We are calling that the Constitution, we know that we are a country that permits 16-year-olds to marry and raise families, but denies them the right to vote or run for office. The voting age must be reduced to 16. If they're old enough to have sex, they're old enough to vote. The minimum age for parliament must be aligned with the voting age. The age requirement for the presidency must be reduced from 14 to the voting age. And I tell you, if a 16-year-old can build a coalition, win the confidence of 50 plus 1% of voters, they deserve to lead this country. 5th, the constitutional framework for environmental justice. We are demanding that the Constitution be repurposed to prepare it for the most urgent environmental crisis facing humanity, by the risk of ecological wipeout. We join various environmental groups such as Arocha Ghana in campaigning for a redesigned framework that prioritizes environmental justice and intergenerational equity, not in rhetoric, but in actual constitutional design. 6, community rights in land and natural resources. We are demanding ecological sovereignty and natural resource democratization. We ask that the Constitution be redesigned to establish national resources as a commons owned by the people, not vested in the president, within a framework for local stewardship and ecological sovereignty. This means never again should it be normal for us as a people where millionaires can make millions, foreigners can make millions from Obuasi, while the town and people languish in poverty. It is not just where we are able to deploy the military to protect foreign assets, and every 2 years kill youth of Obuasi who are demanding access to only leftover mines. All too often, when questions of social inequality come up and stare us in the face, we choose the easy answers: indiscipline, law and order. Every democracy that requires its safety cannot be secured by requiring that poor people accept their poverty and shut up. What does this mean practically? We demand that communities receive an automatic 25% equity in every mining and natural resource exploitation agreement or concession. Natural resources should be vested in the people, and free, prior, informed consent of affected communities must be a constitutional guarantee. 7, separation of powers. Yes, we join the cause for banning MPs from holding ministerial executive positions. But more than that, MPs should not be appointed to state boards, or even as we know now, presidential spokesperson. Eliminating the indemnity provisions from our constitution. A constitution that entrenches impunity cannot preach justice. The indemnity provisions protect past leaders from accountability, and they are staying on Ghana's commitment to the rule of law. We demand that this must be abolished and exercised from the constitution. Some tell us that this can only be achieved with a new constitution. We say, let it come. Similarly, the constitution that indemnifies the president from criminal and civil prosecution cannot be a constitution for the people. 9, this will not surprise a lot of people, abolish the Council of State. I won't say much there. 10, we must end the wage apartheid that exists within the framework of the Constitution. We're asking for the end of ex gratia and Article 71 framework within the Constitution. Every worker, whether they be president, parliamentarian, presidential staffer, minister, or special aid, must be put on the same single spine salary structure. Every worker must be put on the same social security system. How do we insulate our pension system from collapse and haircuts when those who make those decisions are not affected by them? Judicial reforms. The Republic cannot survive without urgent judicial reforms. Yes, we can argue about the Supreme Court needing a cap, but if we constrain the entirety of the reform conversation to whether or not we cap the Supreme Court, we have lost the plot. The reforms must be holistic. Even as we are proposing a cap on the Supreme Court, we must think about the workload of the court. Unanimous FC is a feature of an overworked court. We must think about assigning the supervisory jurisdiction of the Supreme Court to the full bench of the Court of Appeal, for instance, or make the full bench of the Court of Appeal the final arbiter for interlocutory appeals. Judicial appointments must become vested in a truly transparent process. Again, if in doubt, look at Kenya. 12, a recall mandate for elected officials. Citizens must have the power to recall non-performing or unethical elected officials. 14, the president must pay tax. Simple. 15, debt threshold and people's approval. One of the most consequential decisions any government makes is accumulation of public debt. We demand that the Constitution impose a debt threshold beyond which borrowing, as well as any agreements with institutions like the IMF, must be subject to the people's approval through a referendum. This would ensure that the people have direct say in decisions that lead to austerity and cuts in public services or long-term economic burdens. And finally, we are calling for universal basic income as a constitutional right. UBI, as we call it, recognizes every citizen deserves a share of the national wealth generated from our resources. I'll end here. In the beginning, I asked you to entertain doubts, and it's fair to ask me, but what are my own doubts? I do not believe that the critical mass of consciousness that we need to achieve a new constitution currently exists. I have my doubts that critical actors such as Parliament or the Council of State will not sabotage the process as we go along. For instance, I don't see how Parliament, that is salivating over ministerial appointment currently, will agree to end that. I do not see how the Council of State will allow itself to be deleted when it is part of the process of review. And I do not believe that when it comes down to it, the Ghanaian political class would prioritize the people over their own interests. I have yet to see an evidence of this. These are my fears and doubts. I hope I'm proven wrong. Thank you very much.
A panel of Professors Jechi Tano, Kofi Abochi, Dr. Kojo Pumpuni-Asante of the CDD, and Bashira Kamal share their views on this thorny subject.
I really enjoyed Oliver's case, the presentation of his case. I actually want to hear more, particularly if he can also, or the Democracy Hub can show what they intend to keep in the Constitution, because I think that point that he made was very important, that if you, given the process challenges that everybody admits, and Kofi can talk a bit about that, if you show that, well, in reality, we are keeping 80% of what is already there, it might be an interesting conversation, in terms of moving forward. So he's created doubts, and I think that's really interesting. I think even in this short conversation, but we have some views on that. We'll talk a bit about that. But my impression is that he has created more doubts in my mind that maybe this might actually work. So let's see.
First of all, Oliver is an exceptionally impressive character. For the young person that he is, he really should inspire all of us. But I dare say that this gathering is already technically an illegal gathering. And the reason it's already technically illegal is because Article 3 of the Constitution says anyone who suspends, among others, or attempts to suspend the Constitution commits the offense of high treason. I would have limited that to Oliver because he is a prison graduate. And I think he has therefore learned the ins and outs of his awam. But I haven't been there. And what makes it risky for me is that it says, anyone who aids or abets. Now here am I, aiding or abetting. That's on a lighter note. But it's important that we remain circumspect in our expectation. I dare say that if I'm given the chance, I would recommend a constitutional change. But there's no way around it. And I think I've had conversation with Oliver in the past in this respect, because if you change everything in the Constitution from Article 1 to Article 299, that would be a constitution change. But if you leave one thing, that will represent a constitution reform. In other words, if you change out of 299, you change 298. That will represent a constitution reform. Now, there are aspects of the Constitution that are non-amendable. That's part of the problem. That's what the problem is. Ghana's Constitution is perhaps the only one in the world that I know which has provisions that can't be amended. And 299 is one of them. Article 3 is another. Parliament can't even amend it. If all Parliament comes together and says we are amending it, that would represent an illegality. Therefore, we are confronted with a constitution that can send us to bed, worried and frustrated, and we would have to find ways of skirting around it, but constitution overthrow would represent a romantic idea. I would want all of us here to be mindful about its romantic aspect. So Oliver has challenged us to things we should think about, but let's remain realistic about things we can't also do. And I'm just saying this because the 1992 Constitution, in fact, what makes it worse is that even if it is overthrown, it says it will reward anyone that brings it back. So it is the only constitution, well, the 1979 Constitution has something small like that, but it's a bit broader here. It is the only constitution that refuses to die. So what he has done is that if it is overthrown, it legitimizes any insurrection for the future for its ultimate restoration, which means that this current constitution is saying, should there be an overthrow in future, any act of instability, however long it takes, is legitimate. So, ladies and gentlemen, I'm just saying these things, and I can see angry eyes looking at me and wondering why this guy was even invited. But I would want us to remain circumspect, at least in the short to medium term, in terms of what can be done. And I guarantee you, there are things in the 1992 Constitution, like Oliver said, that are not totally bad, that can sustain us and find answers to the things that are problematic. The American Constitution contained a provision that said a black man was 1/5 of a human being. That Constitution still stands. Portions amended. What it means is that a Constitution, I'm sorry, go ahead.
From Prof's presentation to Oliver's, what I see missing is women's right. It was not coming out for me. And we will all acknowledge the provisions for women in the 1992 Constitution, the current one. It's just like a tokenist thing, you know. And if you see me sitting here, I'm very privileged. That's why I have the opportunity of being here. I've had access to education, I've had access to platform, and I've had the opportunity of using my hijab on a day like this, on a platform like this. And these are issues that we are still grappling with as women, when you bring in issues around religion, issues around culture, and so many other issues when it comes to women's rights. Then there's also the issue around women's rights in 27.123, which totally reduces women's existence even in the world of work and in the home to our biological and reproductive roles, because the emphasis is on childcare, is on paid leave. But then there comes the question again about who has access to leave in the workplace and which category of workers in Ghana today have access to leave. We are not even talking about informal women, those working in the informal sector, but working class women in formal spaces, where within the formal spaces, we are a lot of informalization also happening around. Then issues about marriage right. So now if I marry, I'm married, but I mean, if the Constitution permits in future polyandry and I have to add another husband, and I marry another man, and this man is not a Ghanaian, and the man wants to be a Ghanaian, naturalizes. Unlike the provisions for women who would want to be Ghanaians, for men, there is a clause. So if my husband chooses to be Ghanaian, it means that the Constitution says my husband should be living in Ghana permanently before he's granted that right. But for women, it's just given. So why should we have a situation like that restricts my ability to marry? It means that, is it long distance relationship? It's not permitted for women, according to the Constitution, even though it's not written. Then the other issue I'll talk about is 24 on economic right. I mean, and then I'll tie that to 16, which talks about slavery and servitude.
I had the word transformative used in all the previous comments, Prof. Jima, Oliver, and so on and so forth. And obviously, when we're talking about transformative in the sense that I understood it, it means transforming economic structures, social relations, for example, what Bash just referred to in terms of gender and so on and so forth. This points to the fact that a discussion about Constitution cannot simply be about the Constitution. And I think that's an important thing to say, especially in light of what Professor Jima Boadi said in relation to the kind of volatile feelings about the legitimacy or the paramountcy of constitutions vis-a-vis other forms of rule, such as military rule and so on and so forth. We saw at Black Star Square when Mahama was being sworn in, the biggest cheer was for Ibrahim Traore, the Burkinabe leader, with his controversial pistol in his side and so on and so forth. What that points to is that there's a sense in the sub-region and elsewhere in the world where people are questioning the fact that whatever we understand by the norms of liberal democracy simply facilitate the concentration of power, of wealth, and therefore the perpetuation of injustice and so on and so forth. From that point of view, I hope that the lesson that, the first review that Oliver was describing, the one from 2010 to 2011, is taken on board in our discussion. One of the lessons that stood out for me, Oliver's long list of lamentations about what was rejected and not rejected, the fact is that debate was simply between the Commission and the government. No one else was involved. If today we're talking about a coalition, then it means that at least there's a sense that that debate, that conversation has to take its sources from beyond simply the specialized arenas and haloed corridors of those kinds of things. And when we come to that, hopefully I don't know how many minutes is left for a discussion, but those will be critical because we are in a far more of a deeper crisis than any of the comments that have been made here tonight begin to reflect. And it will be important to situate our discussion in that context.
Okay. We can reform it, and I dare say that the way we've gone about it has been part of the problem. We've had too many things we want changed. So even on stage, listening to Madame, she started with her concerns. The concerns about women. Men have concerns. The married ones have concerns, the single have concerns. The unemployed have concerns, the Rasta has concerns. Everyone has concerns. Question is, if you take the entire Constitution, and I think Oliver mentioned that, the recommendations 478. So the recommendations alone are even more than the entire articles of the Constitution, which tells you that there's a fundamental conceptual problem with the way we are approaching it. A Constitution contains things that if they do not change, nothing can happen. And then it contains some things that are not too convenient, but if you don't change them, somehow we can still move along. The American Constitution is way smaller than our Constitution. Our Constitution is way better than the American Constitution, many will tell you. But the American Constitution has survived time. The difference is that they've had institutions that have evolved over time and perfected the parts that need to be perfected. So the question is whether all these recommendations, we need to carry all of them through, or there are some things that we can just ignore. And so take examples. Some will tell you that, and I think Prof captured that in his remarks, that we have an unduly costly constitution The reason is because the framers of the Constitution somehow trusted that we're going to have good leaders. I would say that a good constitution in the hands of bad men will fail. That is what we've had. We've had good constitution, what I still think is fundamentally okay. The problem is that we've had it in the hands of people with the wrong incentives. They are not in public service to serve. These are people who have come into public service with a private investment mindset. Unfortunately, we have a constitution which... Unfortunately, we have a system which is also structured in a way to incentivize that process. For example, we just finished an election. Do you know who funded the contestants? Do we know who funded the political parties? Now, if we don't care about the financiers, should we care about the corruption? We don't seem to realize that somehow there's a nexus, that people make political investment, and for every investor, there must be a return on investment.
To be honest, I don't really know what the assumptions are, because I think there are a whole range of interests. I mean, someone said there's a consensus, or elite consensus, you said. There are differences too in terms of, who wants what, and I think you can tell. But the thing is that there are certain, constitutions would tend to reflect the status quo at any given point in time. Of all the variety of interests that my man, Professor Aboche, mentioned, those which are prominent and strongest at any given point in time will reflect the status quo that the Constitution captures. So he mentioned the American Constitution in 1776, or more precisely 1783, when it said all men are born equal. Obviously, he was not referring to black men who were not men at all. He says they were. And certainly there were no women in sight. Okay? But 100 years later, given the weight of the civil rights movement, you get all of that overturned. It's not simply institutions. It is struggles, movements, that mass action and so on, so are very much part of the transformative process, okay? So we don't have that. That's one dimension. We can refer to our own constitution as well. Jima made an important, very subtle point in his opening remarks when he said that, from 1995, not 1993 when the constitution came in, from 1995, some of us who had no position found a voice. What was he referring to? He was referring to the Kwame Prekum moment. Because if you like, that is when the Constitution actually kicked in as a living reality, because that is when the government, the continuity government from the PMDC into NDC, learned the limits of its power. That is when the opposition and the rest of the citizenry who were not in government or in parliament because the opposition have boycotted, realized that there's political life and agency outside official institutions. So that is when, and so on and so forth. You could say that. So if today we're thinking in terms of a coalition, and I think, as I said previously, that makes a lot of I can see that reflects some degree of progress if we are to reflect on the experience of the 2011-2010 review process, which was simply confined between the government and the commission, okay? But nonetheless, there is not that upsurge of, Bash talked about women. We don't know that there's, large numbers of women making particular claims which have become popular consciousness, people are fighting over, people are debating about, which will find its way into a constitution. What we know is rather different. We know, for example, that the government and the ruling class as a whole, they all promised in their constitution, in their manifestos, that they will do constitutional reviews. One reason is that they're nervous. The same reason that Ibrahim Traoré got the biggest vote, there is a crisis of legitimacy at the heart of the state. Phrases like state capture are being bandied left, right, and center. So there is for that. So obviously, if you're part of the government, part of the ruling elite, you want some sense in which that some legitimacy can be reclaimed, some degree of realignment between some of the concentrations, the imbalances between the executive and the legislature, so on and so forth, that Jima referred to and so on. Some of those things are realigned and so on. But I don't think those begin to go to the heart of the real fracture in society. A society is deeply divided precisely because it's deeply unequal. It is more unequal than it has ever been, even on the official statistics.
So far, the contributions from everybody point to one thing. To approach any public policy action, I think the basic question you have to ask is, what is the problem that you are trying to solve? Right? And this is what we are all trying to get to. And that's what I think sounds to Kofi as there's a lot of issues that we are trying to pile onto the Constitution, because the question we ask ourselves is the Constitution going to solve all the even some of the issues that we've just discussed if we just wrote it into the Constitution, right? Is it an issue of constitutional design or something else? For example, you talked about statutes, you've talked about subsidiary legislation, for instance. And a lot of those issues, no matter what you say in the Constitution, you have to elaborate it somewhere for us to understand the different conditions under which that principle is applied. Right? If I think about the problems that currently we are trying to address with the Constitution, I think of 4 broad areas. There is the transparency and accountability issues. That's where we talk about all the checks and balances, horizontal accountability issues, and so on. Then you have a very big problem, and it's not an easy thing to solve with a Constitution. How do people who are appointed or elected to serve our interest actually pursue the public interest? How do you create incentives? How do you design the Constitution to make sure that when that person gets to the office, he's always thinking, I have to serve the public, I have to serve the public. As Kofi is saying, the person is rather thinking, you know, I've spent all this money coming here. I owe, you know, 100,000. What was the last? I think right now is $675,000 for an MP, which is about 10 million Ghana cedis. So if you are coming into that office with 10 million Ghana cedis debt, and you are hoping to clear the debt, make profit, so that you can go for the next time. So already the whole problem, whoever the beneficiary is not going to get anything good out of that process. So I think that's a challenge.
Let's take it that our vice president was here with us, and she was introduced. I mean, I'm not wrong to use he, actually. I'll come to that. So the way she introduced us, if she was introduced, and then the profile is being read, and then she wants to use a pronoun, the Constitution recognizes her as a he. So there's no she in the Constitution. So because of that, our vice president currently, if you want to use pronouns on her, you are warned. It has to be a he, not a she. And when we were having this discussion, I remember someone telling me, what is wrong with that? I said, oh, there can be nothing wrong with that. But then let's agree to use a she. After all, he is in what? She. When I was looking at the Constitution, one thing I saw, which I'm still trying to understand, is the definition of everyone, every worker is entitled to have equal pay for equal work. But the convention that Ghana ratified to have that didn't say equal pay for equal work. It said equal pay for work of equal value, so that there can be a measure. So nobody will use their discretion, or like Basile would say, discriminatory tactics, whether on ethnic basis, to say that, oh, the work that Bash did is equal to the work that Kojo did. So because of that, I'll pay all of them 5,000 Ghana cedis. You know, so there's a fundamental flaw in that. Then we also recognize that there's an issue with economic rights generally, where 24 talks about workers' rights. But if you look at it, there are a lot of issues around the workers' right. There's slavery and servitude provided for. There's forced labor, obviously thinking that it came from the abolition of the Forced Labor Convention. But in the labor market today, they have a new term, modern slavery. However that came to be, I don't know. But there is modern slavery. So it even defeats the purpose of what is in the Constitution, because people are able to work around it to do what they want to do. And when it comes to that, it is women who actually lose, because in the labor market today, from my experience, some of my leaders are here. When you go for a recruitment interview, Whilst men are being asked about what they are bringing on board, it's just like when women are campaigning to go to parliament for a political office. People are so fixated on their reproductive roles. As a woman, who will take care of your children? There are meetings that runs late in the night. Who is going to do this? Security issues. But we are not thinking about how to protect them. I can confidently tell you that in the labor market, women are asked questions about, are you married? If you marry, how many children do you want to have? Some who have already been working in organizations are asked questions like, since you came here, how many times have you been on maternity leave? To determine whether you deserve promotion or not. It doesn't matter the number of years you have served in that particular organization.
Great intellectual views there by the panelists. But how do we fix the Constitution? Fixing the country. This is the law. It's your legal light. It is your help law. Have a good afternoon.
They say fix the country. We say fix yours. Fix the country. Beautiful. Hey, now who be the country? Me be the country. You be the country. So fix yourself. This is the most annoying part. Your minimum wage be hand to mouth. The government know they pay for months. From the same pay, Peking go chop. Your bills go come. Yari the ball. Servants then magicians building mansions after few years. Now who cares about the coffers? And each man living for himself. We say fix the country.